Thank you very much, Madam Deputy Speaker, and it's a pleasure to follow the honourable lady who, although on an opposite side of the debate to myself, always speaks with huge passion on these issues. I should start with a couple of declarations. Firstly, my wife is a sitting employment judge, and therefore the tribunal element, of course, pertains to her. And like many honourable and right honourable members in this chamber, immediately prior to coming into this place, I was a barrister, and I maintain my practising certificate. So I hope the honourable lady will indulge me pontificating on this issue for a few moments. And whilst I was not a criminal barrister, I did do a significant amount of inquest work. And so I had face-to-face, first-hand experience with jurors. And I can say, without a shadow of a doubt, they are the most remarkable, ordinary people who give up their time for civic engagement. They sit there quietly listening to the evidence. They take their role seriously, and they sit in judgment and make findings of fact. And that is a huge constitutional principle. We've talked about rights, and I'm not going to pretend there is an innate right to a trial by jury, but there is a firm constitutional principle about ensuring that justice isn't merely done to the public, but it is done with the public. We all know the problem with the court backlogs. I mean, it would be a farce to pretend that this was not a significant and serious issue. It is a failure. It is a failure of the states that we have got to this place. It is a failure of successive governments, and we recognise that across the board. But the question that we have to ask ourselves, is not whether trial by jury should be abandoned. It's whether these reforms before this House, with the scrutiny that's been provided, with the impact assessment that accompanies with it, is sufficient evidence to make such a constitutional reform to this country. And what we are asking is very clear, and we have to be honest about it. We are asking for a shift in the balance between the state and its people. And if we are going to do that, that may lead to inequality before the law. Take the prime example that my right honourable and learned friend raised, where you have two individuals who, on a factual matrix, did precisely the same crime. They appear before the courts, but one has a string of previous convictions. Are we really saying that they should be denied the opportunity for a jury trial if they had not previously been of bad character? That is a nonsense. It is a nonsense, and it doesn't achieve what we should be seeking to do. The further point, of course, is that if we're making such a constitutional change on the basis of dealing with the backlog in the criminal courts, why is there no sunset clause to this? Why are we not saying that this is to change, to shift the dial and to move it forwards? But we recognise that this should not be a blank cheque for the state. We should be recognising that if this has to be done, and I don't believe it does, but if this has to be done, it should be done on a limited basis. Because if we are to change a right that is older than most institutions within this country, the least Parliament should do is do it based on more than just an assumption that is in the impact assessment. And I want to come on to the modelling, because it was raised by my honourable friend, the Shadow Justice Secretary. On the 3rd of February, I raised a question with the Lord Chancellor in this House in respect of the 20% reduction in court hearings. And he gave me a very clear answer. He said that you accepted the findings of Sir Brian Leveson, but the government would publish its own modelling alongside the bill. Well, page 10 of the impact assessment is very clear. The government have adopted Sir Brian's assumption. That is an assumption, that is not modelling. There is a distinct difference. Analysis is helpful, but modelling is critical. And if we are weighing up the evidence base for this, we have to have more than analysis alone.
Will you give way?
I will give way.
I'm very grateful to my honourable learned friend. One of the issues I wondered if he could just give us his views on as a practitioner that hasn't yet been mentioned in the debate, is the usefulness of juries in protection of the institution of the judiciary. At the moment, if there's a string of sentencing which the government or politicians don't like, there's not a lot they can do about it. If it's judges who are handing out those sentences, then they will come under direct political attack, as unfortunately we do see from time to time. And that distance and that insulation that a jury gives is not just a protection for the citizen, but also for the judiciary and its integrity ongoing.
Neil Shastri-Hurst.
I'm very grateful to my right honourable friend for his intervention, and he is right. There is a reason judges wear a wig. There is a reason barristers wear a wig and gown. It is to provide a shield between the arm of the law and the citizen. And to dilute that would fundamentally upset the settlement that has been reached over hundreds and hundreds of years.
Can I draw my honourable friend on that point?
I will give way.
I thank my honourable and learned friend for drawing that point. We've also heard much argument that somehow reducing down to one judge would be a fairer and less biased system. But as a woman, I don't feel that one, and we have to be honest with ourselves, likely man, who does not share my life experiences, is more likely to be less biased than a jury of my peers. And actually, if the government really wants to tackle this, they need simply turn to page 67 of their own manifesto, where they promise fast-track rape cases with specialist courts at every Crown Court location. Surely that would be a better location, making sure that women, when they give evidence, are hearing from a jury of their peers who are more likely together to understand their life experiences than one individual.
Neil Shastri-Hurst.
I'm grateful to my honourable friend for her intervention, and she is right. Firstly, there is the argument that this is of such constitutional significance that it should have been in the manifesto.
100%.
Secondly, there's the argument that there was a proposal within the manifesto that the government are not bringing forward. And thirdly, this is about getting the right settlement for the public and being judged by a body of their peers on the evidence before them, opposed to a distant or perhaps at times appearing an aloof judge fails to achieve that balance. And what we're being asked today, of course, is to curtail a constitutional safeguard that has been apparent for so many years. And it goes much further than Sir Brian's report. There were many good things in Sir Brian's report. But this, of course, goes much further than any of his suggestions. And we have to ask the question of what are the real issues? Well, the real issues are very plain to see. There are too few judges, there are too few advocates able to prosecute or defend the cases, there's too few functioning courtrooms. Removing jury trials won't fix any of that at all. No, exactly. And there is a further issue that the government have failed to address, which is around the recruitment of magistrates. We know that in this country, recruitment cycles of magistrates have often not returned the numbers that have been required. The presumption must be that the reason the government didn't adopt Sir Brian's recommendation of having 2 magistrates as wing members was because they knew they couldn't recruit sufficient number of magistrates to deal with it. Well, that's logic on that front, but if you're pushing more cases down into the magistrates' court, who is going to be able to hear them and listen to them? Who's going to be able to draw those conclusions? And the final point that I will make very briefly is it pertains to parliamentary scrutiny. This bill is going to be rushed through this House. It's going to be rushed through committee. A mere 5 days in committee of such constitutional importance. Such constitutional importance.
5 days.
There is strong feeling across the House, both for and against these proposals. Would it not be wiser in such circumstances to adopt an approach, as we do for the Armed Forces Bill, for example, where we have a select committee of the House with those members who have experience within the law, have experiences of being victims, to scrutinise this, to come back with a report and then do report stage on the floor of the House, so that the country can know that we have given this the due regard that it deserves. Yeah. There is a reason that jury trials have endured, and it's because it commands the trust of the public. It ensures that the law is exercised with public participation. And if the government believes in diluting that right, then they must provide the evidence for that change. And thus far, they have failed to do so.
Hear, hear.